Stop everything. DHS has ended automatic extensions of employment authorization. That means thousands of people could lose the right to work in the US overnight. What does this mean? Who is impacted? Who is affected? And most importantly, what should you do right now to protect your work status? Joining us is immigration attorney Jonathan Wasden from Wasden Law, who is going to help us get answers to all these questions. John has helped a lot of immigrants navigate complex immigration and visa issues for a lot of years, and today he's going to help us with getting all the answers related to all these questions. If you have any questions related to EAD, make sure to drop them in the comments below. And also, I'm going to read out very soon a phone number which you can give us a call on. But for now, before I welcome John, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back everyone to Immigration Talk Show. We are live on Facebook, Twitter, and also on LinkedIn. And make sure to like the video, share this video with anyone who you think can benefit from all this information that we are going to have in today's discussion. And also subscribe to all of our channels. But now, without any further ado, let's welcome Jonathan Wasden on our channel. Hi, John. Welcome back to Immigration Talk Show.
Hey, good to be here. Thank you.
Thank you so much, John, for being here. Guys, if you have any questions that you would like to ask John, please make sure to drop them in the comments below. And also, I would like to read out that number for you so that you can give us a call also on that number and directly speak with John. And that number is 425-436-6335. And you can put the access code, which is 988888. Now, John, let's start with the basics. I would like to ask you that what does this exactly mean? You know, what does this mean that DHS is ending automatic EAD extensions? And for people watching, how was it working before this change?
So, maybe the better starting point is to go all the way back to 2018 when the real problems with the first Trump administration kicked in. Mm-hmm. And that's when we saw them create this bogus requirement for everybody who's getting an H-4 visa extension to get new biometrics. And it applied to the L2s, the E2s as well. That was something we litigated pretty heavily. And it turns out in the government records that all of their explanations for why this biometric requirement was necessary were bogus. And we caught them in that in court. So they got rid of the biometric requirement, but they were refusing to concurrently process the primary H1 or L1 with the derivative spouse, their applications for extension and EADs. And the decoupling of those things, which had always been done together, the decoupling caused massive delays. So instead of one adjudicator looking at 3 petitions that are all the same information, now we have 3 different adjudicators shuffling papers back and forth in a kind of a messy, complicated process that ended up, delaying things substantially. What that meant was, the earliest you could file your EAD application and your extension of status is 6 months prior to its expiration. So when USCIS is taking 9-10 months, you're out of job at the end of the 6 months, and you have a period of unemployment. And it became very difficult for H4s, L2s to maintain employment because employers were scared that if they have this person, they're going to lose their employment authorization, and there was no predictability as to when they could be back at the job. So, that was the next issue. And the result of all of that litigation, a couple of things. One, biometrics were suspended for the status extensions. And they recombined the primary, the derivative applications. The other thing that we were able to do, just because of a difference in the statute between L2s and H4s, is we were able to get the agency to concede that L2s don't have to file an EAD application. They have employment authorization, what's called incident to status. And that was something that had been, to me seemed very clear and inherent in the law, but the agency had just never acted on, and nobody had ever pushed that issue before. So we litigated that, and we got L2s, their employment authorization incident to status. We got them to combine back the adjudications, and also made H4s eligible through that litigation for auto extension. And then they, were tired of getting sued by us, because I think we had more than 2,000 clients that went through this process and got their EAD cards through the mandamus process. And so they're tired of getting sued. So then they went through the rule change and the regulatory process of allowing auto extension on renewal applications for EADs that last for up to 540 days. And that was kind of an acknowledgement on USCIS's part that they are a bumbling organization that is horribly inefficient. And they wanted to give themselves a ridiculous amount of buffer space so that, at the end of that EAD, they're not getting sued, and they have ample time to do any RFEs, any, further development verification that they need to before, adjudicating the EAD. So that's the background. That's where we came at. And all of the settlement negotiations and settlement agreements we had expired on January 20th of this year. And that's when you see the Trump administration do its first move against the H4 EAD especially, which is they said they are no longer obligated to concurrently process. Now, a lot of people are still getting concurrently processed, which is great, but legally they're not required to do that any longer. What we see now is by getting rid of the auto extension, it's pretty clear what they're trying to do. They're trying to create new hurdles to the adjudication process, and they're going to delay the adjudication of these EAD applications well beyond the 6 months. The application is extreme, and they're going to put that over the edge, and that's going to force people out of it, and that's going to impact everybody who's got an EAD that needs it renewed. And they're trying to eliminate as many people, especially the H4s. Now, the H4s under the Trump administration were targeted pretty heavily. And they were going to try and get rid of the H4 EAD through the regulatory process, but they could never get it right. The Office of Management and Budget within the White House kept returning the proposed rule back to USCIS because it kept screwing up the rulemaking process. So what they couldn't do legally through a rule change, they're trying to do by creating hurdles or obstacles in the adjudication process. And they're trying to kill the program by a death by 1,000 paper cuts, by slowing down the adjudications so that you lapse on your employment authorization and you have to leave the workforce.
Okay. So, John, a lot of bombs are being dropped one after the other. I mean, I think I was watching this conference. I think it was Kristi Noem, if I'm not wrong. And in the conference, they were saying that the reason to do this, the reason that they gave the public is that because they want to vet each and every application properly and for the public safety and national security. I think this was the reason that was given. So I would like to ask you that, what do you think about this reason? Do you think this is the reason behind why this sudden decision has been taken?
That is the most disingenuous explanation I've ever heard. So if you look at the process, these are not people on their first EAD or their first visa, right? These are people that have had status, had an EAD, and are applying to renew it. So they've already been vetted multiple times. We're not questioning about what their identity is. We know who they are. We have their biometrics stored in a computer. We can verify who they are. So really the only question when you're looking at, say, like an H4 EAD renewal is, are you married to an H1 and do you have H4 status? And if you do, and your spouse has an I-140, then you're eligible for an EAD. And there's really no national security implications here. So the silliest thing about that whole argument is, so you can stay in the country legally, but somehow being in the country is not a national security threat. But you working at the hospital becomes a national security threat. It's just completely illogical, and it doesn't make any sense. And that's one of the problems they're going to have when we start litigating this on this rule and fighting back on it, is they're really not going to be able to have a cogent explanation that's going to, be persuasive to the judge.
Okay. Thank you so much for answering the question, John. And I would also like to know that when does this, this rule officially take effect? I think it's today, right? 30th of October?
Yeah, so kind of interesting. Ordinarily in the regulatory process, what they have to do is do a notice of proposed rulemaking, allow between 30 to 60 days for the public to respond, take those comments and then analyze them and then publish the final rule. So in emergency situations, they have the ability to skip the proposed rule stage, and they can do what's called an interim final rule. And that's what they've done here. They've skipped the normal regulatory process, claiming an emergency. And that emergency, funny enough or embarrassing enough that they're actually claiming this, is based on the president's proclamation or executive order protecting America from invasion. So, that's, again, one of the other absurdities of this whole mess is, the basis of the rule is just completely not there, not consistent with what they're saying. The only real logical explanation of what's happening here is they just want to eliminate as many people out of the workforce as possible. And how they think those jobs are going to fill, I still don't have a good explanation for.
Yeah, absolutely. Again, thank you so much for answering the question, John. So just to be clear, after October 30th, even if someone files early and on time, they can't keep working until the new car is approved, correct?
Yeah, so if they can file 6 months before it expires. So, assuming their EAD expires in 6 months, they could have filed on the 30th, and they need to be very carefully watching that clock, because when you start to get to the 4-month mark, that's when you really need to start thinking about mandamus, because it's going to take 60 days for the government to respond to your case in court. And if you're 4 months plus 60 days, you're at 6 months. So you need to get that thing in there so that you can be ready to litigate and not have a lapse in your employment authorization. But the moment you file, and if you've already filed, you need to go back and do this. You need to do a FOIA request for a particular data set. And that's something that we're going to be holding some other webinars on our closed channel, just to tell people what they need to do. And we're willing to file those on your behalf. We won't be charging for that right now. We just want to get that data so that when we have to make this fight, we can do it. But if you were filing in H4 or any extension, make sure, this is absolutely necessary, make sure you include a detailed description of what you do, why you will be impacted if you lose your job and you lose your work authorization, how your employer is going to be impacted. The reason why you have to do that, it's not just filling in a form and sending it off. And this is a new game. We're going to have to try a little harder here on these cases, because in the law, when it talks about how long the government is allowed to take on an adjudication, one of the factors they have to consider is the necessity and convenience of the applicant. If you don't put that information into the record, into your application, they have nothing to consider. And when we get in front of a court and we get to the judge, we're not going to be able to argue that you made clear what your necessity and convenience was and they ignored that. But if you put that evidence into the record, they have nothing to rebut that. And that is one more thing that kind of builds your case and makes it stronger. And then we couple that with the processing data to show that, the government's allegations about how fast things are moving and what the resource limitations are, they're all bogus. They don't hold water. So put all that together and it makes a much stronger case. If you're filing an H-4 extension though, and you need help getting that statement together, explaining your necessity and convenience, happy to work with you on that. Especially for those, jobs where people are in, healthcare, medicine, school teachers, professors, anything that has like a public benefit or a public service component to it. Those are cases where you really need to lean hard on the impact you're making to the community and how the community is going to suffer if you're unable to work.
I mean, John, the immigrant community was anyways inquiring about, the lawsuit and the verdict of the lawsuit regarding the H-1B $100,000 fee. And now, this another rule has come and now they will be again inquiring about this lawsuit and the verdict of this lawsuit. So now without giving any heads up, without, giving any notifications, rules are suddenly just being implemented. So what do you have to say about that? Do you think it's fair?
The EAD auto extension rule is fair? No, I don't think it's fair. I think
that on the $100,000. I mean, all of these rules, they are suddenly being implemented without any notification or any heads up.
Yeah. So the $100,000 fee, the U.S. Chamber of Commerce is taking that on in the District of Columbia.
Yeah.
They have honestly one of the best Supreme Court advocates in the country as their counsel in that case. That's a case that the chamber's most likely going to knock out of the park. They have a great judge, they have a great counsel, they have great arguments. And it's very clear what happened in that situation is the president is just trying to bypass statute and bypass the regulatory process and create a new fee that is not authorized in the law. And as of now, we don't have a king. He still has to work through Congress and he still has to follow the law. And there's really not a lot of great arguments on the government side for why this was legit to just instantly create this new fee. The other thing is fees that USCIS charges or collects have to be tied to the amount of work that they're performing. It's to recoup costs, not to make money. So they're recouping adjudication costs and expenses that they incur. This $100,000 fee, there's no way that you can ever say that $100,000 fee is paying for a particular service. It's impossible. So it just doesn't hold any water there either.
I'm sure people must be really thanking that they are living in a democracy and for the Constitution because of what is happening, these days. So thank you so much, John, again for answering the question. And guys, I would like to remind you about something. Our private webinar is coming up this Wednesday, November 5th at 4 p.m. Eastern, titled DHS Ends Automatic EAD Extensions. Are you on the list? John will be joining us to share his experience and will dig into what this change means, plus discuss important details about a potential lawsuit you won't want to miss. It's a private event, so to join, email support@wasden.law and reserve your spot today. Again, that's DHS Ends Automatic EAD Extensions. Are you on the list? Wednesday, November 5th at 4 p.m. Eastern. Email support@wasden.law to get your invitation. All right, after this, let's come back to our questions. And maybe before taking our questions, let me take our viewers' questions because I think people have joined us and they have started posting their questions. So Rajendra Singh is here. Rajendra says, if an EAD renewal application form I-765 was timely filed before the EAD expiration and before October 30th, 2025, then it is not impacted and is still eligible for auto extension. Is that correct?
That is correct. So if you had an existing EAD and you're not changing your category and you're just looking to renew the same category, same visa category, then if it's filed before the 30th, you do qualify for auto extension. After the 30th, no, you don't. So just make sure you have your receipt and make sure that that receipt that gets sent to you, that notice of action, the 797, reflects the correct date. So if you have tracking information about when USCIS actually received that, you might have to force them to issue a new 797 with the correct date just to show that you are eligible for the auto extension.
Okay. Thank you, Rajendra, for your question. If you have more follow-ups, please, you can continue to post them in the comments. Meanwhile, let me take Madhura's question. Madhura says, under what specific legal provisions or Federal Register notices can individuals still qualify for automatic employment authorization extensions, particularly those under temporary protected status?
So for auto extension, if it's authorized or required by statute, then they're still going to qualify. But for things that are discretionary or things that are regulatory, those things can be cut off relatively easily. So you really have to just trace it back and figure out, which category am I in? Am I in discretionary? Am I in incident to status under the statute? Or am I in a regulatory grant? And then, figure out where you are on that spectrum. That'll tell you if you qualify for employment authorization auto extension. If you're, in that category of lucky folks like an L2 or an E2 even, that has employment authorization incident to status, you don't really have to worry about this. You've got your status, and as long as you have your status, you can work. It's really more of the folks that are in that regulatory category, where the agency has created an authorization or allowed an authorization for a particular set of people. Then they have to apply to renew that. And that's where you're going to be impacted by this change.
Okay. Thank you, Madhura, for your question. I hope you've got your answer. If you would like to post more of your questions, so you can, continue posting them in the comments below. And also you can give us a call on the number 425-436-6335. And you have to put the access code, which is 988888. Yes, you can directly speak to John and ask your questions directly if you would like. So please do give us a call too. And John, I would like to come to you and ask you that, considering we have already seen long processing times. So do you think, isn't DHS risking more backlogs and employment gaps for workers and, companies with this decision?
Well, I wouldn't say from DHS's perspective they're risking that. I would say from their perspective, they're trying to make that happen. So they're not concerned about, people losing their jobs. They're not concerned about companies losing employees. They have an agenda, which is to eliminate as many foreign workers as possible. So everything they're doing is calculated to achieve that end. And this is by design. They are trying to make it as hard as possible for people to maintain their jobs if they're on, one of those categories that has to extend an EAD and doesn't get an incident to status. So, yeah, they're designing it this way, and they will start creating new requirements for adjudication hurdles that you've got to go through, or internal processes will change that will extend out the time of adjudication. And that's going to push people out of employment authorization. That's why we need to get these FOIAs going, so we can request internal policies, internal memos, emails between agency execs and the White House, looking for motivation for what they're doing, as well as really granular processing data that shows whether or not they are actually processing in a first in, first out method, and whether or not they are actually taking into account your necessities and conveniences as the applicant. So, all of those things are going to be essential to push back and fight back against DHS's design of pushing people out of the employment market.
Okay. Okay. Thank you so much, John, for answering the question. And I think Manan Pathak is also here from LinkedIn. And Manan says, are H-1B holders applying for extension impacted by this change?
So the H-1B isn't, no, because they have employment authorization incident to status. And the statute, you're given employment authorization when you have an H-1B. It's the H-4s and the derivatives and other categories that get their employment authorization through the regulation, and that they have to apply for employment authorization. So those are the folks that are going to be impacted by the lack of auto extension.
Okay. Manan, I hope you have got your answer. If you want to know the answers to more of your questions, please, you can post them in the comments below. And HS is also here. He says, hi, thank you both for doing this. Do you think there's a possibility of litigation leading to a judge putting a hold on this rule? If so, by when?
So yes, I do. And that's something that we're already trying to work on and to get some support for, some backing and funding. I think it's very possible. I would prefer that we kill this thing early on instead of doing what happened last time where we fought this out for 2 or 3 years through the mandamus process. If we could get a clean kill up front, that would be preferable. There's a lot of weaknesses in the government's case, but the process we need to follow first is there's a comment period after the effective date. So ordinarily the comments precede the effective date, but here they got it backwards because they're claiming an emergency. We need to make comments attacking their rationale, attacking their lack of data and evidence supporting their conclusions, and we need to submit those comments. When the comment period ends, the rule is final, and we can go immediately to court on that. And the comment period is going to end on December 30th. So we will be ideally ready to go to court with a preliminary injunction at that point. Ideally, we would be able to get a couple of folks who are, in this situation of filing after the 30th of October, and who will be facing immediate harm if the court doesn't act. And so, the legal arguments I think are sound. We just need the right plaintiffs. Ideally, we'll get some doctors, some nurses, some people that are in public service sectors that are in this situation that want to fight because they like the most sympathetic plaintiffs, quite frankly. And they also show the benefit and the contribution that the immigrant community is making to the U.S. And that's, something we definitely want to highlight, that the government is hurting its own people by pushing these folks out of the labor market.
There you have it, HS. So it's most definitely going to happen. But talking about the date is not decided yet. So maybe you just have to wait and watch. But it is, like John said, it's most definitely going to happen. Thank you for your question. And you can continue posting your follow-ups. And Sanjay Verma is also here. Sanjay says, what legal procedural options exist for H4 spouses, C26, and other dependents who now face a lapse in work authorization due to the rule change? Can expedited processing or alternative visa strategies be pursued?
So really your only option here, if you're still in the H4 category, is to file a mandamus case. But before you file the mandamus case, like I said earlier, you need to file the right Freedom of Information Act request to get information from the government that we can turn around and use against them in the mandamus case. So last time around this happened, like I said, we probably over 2,000 plaintiffs that we took care of, and we got their EAD cards for them. And, if you time it right and you prepare your case right, you should be able to avoid going into beyond that 6-month mark where you lose your employment authorization. So, timing is key, preparation is key. So you do have legal options. I always tell clients, the government can screw up your life in the blink of an eye, but it's going to take you a long time to fix it. And this is one of those situations. They can screw things up very quickly. It's going to take a lot of work on our end to fix things and get you back on track.
Okay. Thank you again, John, for answering the question. Sanjay, I hope you've got your answer. Thank you for being here. And yes, again, you can continue posting your follow-ups. And I would again like to remind you all that our private webinar is coming up this Wednesday, November 5th at 4 p.m. Eastern Time, titled DHS Ends Automatic EAD Extensions. Are you on the list? John will be joining us to share his experience, and we'll dig into what this change means. Plus, we'll discuss important details about a potential lawsuit you won't want to miss. It's a private event, so join. Email support@wasden.law and reserve your spot today. Again, that's DHS Ends Automatic EAD Extensions. Are you on the list? Wednesday, November 5th at 4 p.m. Eastern Time. Email support@wasden.law to get your invitations. Thank you so much, everyone, for being here. And yes, I hope you're enjoying this conversation. If you are, make sure to like this video, share this video with anyone who you think can benefit from all this very important information, and also subscribe to Immigration Talk Show and also to all the channels of wasden.law. Thank you. And John, again, let's talk about who's hit the hardest. Which categories of EAD holders are most affected by this new rule?
So I think H4s obviously are hit hardest because they're some of the most highly educated of the non-immigrant community. Oftentimes, they have more high skilled and better paying jobs than their H1 spouse. And so I think those folks are the ones that are really going to be taking a hit here. And really anybody that is facing this, that needs to subsist and needs to work to live, is going to be hit especially hard. I mean, we let people into this country and then we tell them you can't work. Well, how are they going to live? And so those people that are on the margins as well are going to be hit, disproportionately hard. And that's why ideally we will knock this out and kill this thing early before we have to get to the mandamus stage. But if we have to fight it at mandamus, we just need to be ready, and we need to get the right evidence through the Freedom of Information Act.
Okay. And are there any categories that are safe? Maybe, people under temporary protected status or certain humanitarian programs?
So as long as you're having to file an extension of your EAD and it's not statutorily protected, you're going to have an issue.
Okay. Thank you so much again, John, for answering all these questions. And again, I think we are constantly getting questions from people. So Manan says, thank you. And Ranjit is also here. Ranjit says, for individuals whose employment is considered incidental status, are there any scenarios where they might still require an EAD? And if so, would the new rule affect those cases?
So it's funny that you bring that up, Ranjit, because in the rulemaking analysis, they bring up the issue of an L2, and they're very upfront that L2s don't need to apply for an EAD. But if they want to apply for one as a identity document, they can, but then they can't work once that identity document expires. Which, to me, it just begs the question, why in the world, if you're an L2 or an E2 for that matter, would you apply for an EAD when you don't need one and run the risk of being found ineligible for employment when that EAD expires? It's just a waste of money. It's a need unnecessary stress to your life. So if you have an incident status, you don't need an EAD, and you shouldn't engage in that.
Okay. And John, what about the ones who have applied for their renewal before October 30th? Are they safe under the old rule?
Yes, and you just need to make sure that you actually have a receipt that shows the correct dates. I'm not putting it past USCIS to screw that up and to post-date people's receipts and say that they were arrived after the 30th just to screw with people. So use your tracking information, make sure that you have evidence for when it was actually delivered. And if there's a discrepancy there, if they're saying you don't qualify, that's a relatively easy fix. We can elevate it through a service request, but more likely what we'll have to do is we'll just file a complaint in court saying the government screwed up and put the wrong date on this form, explain why it's necessary. No U.S. Attorney's Office in the world is going to want to fight that case. And so, there are ways to fix it if the government screws up.
Well, at least that's some relief for people who acted a little early. But how long could someone be stuck waiting without the ability to work if they file after this date?
Well, before we really started attacking this issue during the first Trump administration, people were out of work for over 6 months to 8 months. So, there was, extreme examples of people that, they applied and were waiting for, the EAD in their status for a year and a half after the fact. So, I don't think there's a set time limit that USCIS is going to trigger that makes them actually do something. From their perspective, they're content never to do anything. And they're, content to let people get out of work and get out of status and wait until, somebody raises a stink and fixes this thing in court.
Absolutely. Thank you again, John, for answering the question. And let's talk about, what should people do right now to protect their, work status. So what should EAD holders do right now if their card is expiring soon? And is there anything proactive that they can do?
So when they file their application for a renewal, there is a particular data set that we would say you need to request. It's going to be very particular. It's going to be particular to your category, your EAD category, as well as the service center or office that's handling the adjudication for that. And so we need to just really drill down to see, what is actually happening behind the scenes in the processing. The other thing is, memos, emails, information that is going on internally that's setting policy and adjudication guidelines and requirements. So all of those things are in the FOIA. Once we get the FOIA, and once we submit the FOIA, rather, the government has 20 days to respond to the FOIA. If they don't, we can go to court and we can sue on the FOIA. The great thing about FOIA is if the government fights you and loses in a Freedom of Information Act request, they have to pay your attorney fees. And as odd as this sounds, that is probably the most hated thing in the world for USCIS is to pay my attorney fees. And so what we find is they kind of jump through some hoops to avoid paying me attorney fees. And one of those is, if we combined in the same lawsuit, the FOIA lawsuit and the mandamus lawsuit, these things, historically, magically settle because the government does not want to turn over that data. They do not want to provide those emails. They don't want to provide the processing information to show what's really happening behind the scenes. And so if you do it right and you hit a sensitive spot within the agency for something they don't want to disclose, things tend to work out better.
Okay. And what about the dependents, the H4s and L2s who mostly rely on their EADs? I mean, does this mean that they are going to lose out on their income?
Yeah, if they get into that spot where they have lapsed on the date of their employment authorization document and they don't have a new one and they don't have an approval, then they can't work. And there's penalties for working without authorization. So you just once you hit that point, you have to stop working and wait. And some employers are better than others in terms of working with people and being understanding. But it's a horrible spot to be in. People have mortgage payments. People have ever increasingly more expensive grocery bills thanks to tariffs and things like that. And life is expensive, and to lose one of the incomes, and sometimes it's the better paying job of the family. It's tough, and that's why people need to take control of their future and manage their own destiny, and be proactive early on. Don't wait. Don't trust that USCIS is going to do the right thing by you. Don't trust that they're going to be processing as they should. You need to be prepared for when they screw up, and you need to be able to fix that before it has a massive negative consequence on your life.
And John, speaking of the help, is DHS offering any, grace period or transition help for those caught in between?
No, so that's the crazy thing. They came out with this interim final rule, and it was effective the next day after it was released, and there was nothing. There was no provision, no gradual phase in. It was, if you file your application tomorrow, guess what? You're screwed. And so there's really no indication coming out of DHS in general that they're looking to do anything to help people, in the immigration space. They are treating the EAD program the same way Kristi Noem treats puppies, and they're trying to kill it. And so, that's the sad fact that we're dealing with.
Okay.
And for those that don't know, Kristi Noem famously wrote an autobiography where she describes killing a dog that was misbehaving. So she's a real gem.
My goodness. Okay. I suddenly have nothing to say on this. But thank you so much, John, for answering everything, in so much detail. And we are constantly getting questions from our viewers too. Let me take them. Given USCIS's monthly backlog in processing approximately 52,000 EAD renewal applications, what legal safeguards or interim solutions exist for foreign workers now at risk of employment gaps and status uncertainty due to removal of the 540-day automatic extension?
So the only legal protection you have is mandamus litigation, unfortunately. I wish there was a better answer. I wish we were dealing with a rational government agency that, saw the value in upholding processes and upholding the law. But right now, we're not in that space. Right now, we're in a situation where they're actively trying to screw up the processes that are in place under the law. And so you've got one option, essentially. If this new regulation isn't killed on what's called a facial attack by just directly suing on this policy, then the issue becomes fighting mandamus litigation for individuals. One of the issues that we litigate in mandamus is, whether or not there's a competing priority that's more important to the government in terms of allocating resources, money, putting employees to work on a particular problem. Historically, USCIS has always, pled poverty. They say, we don't have money to do this. But they just went through a massive fee increase. They created a massive new asylum program fee. At the same time, they cut way back on asylum adjudications. So they're sitting on top of a mountain of cash, and they're not spending it to fund adjudicators, which they are required to by law. They're spending it to fund ICE and FDNS to go out and play tough guy out on the streets and walk around with the AR-15s. So when it comes down to it, in terms of whether or not the delay is excusable or reasonable, one of the issues we're going to be looking at is funding. How is USCIS using the funds that it has, and are they using those funds for a lawful purpose? And I think at the end of the day, what the courts are going to rule is that they are not. That the law is very clear. They take in adjudication fees, and it's supposed to pay for adjudications. It's not supposed to pay for guys wanting to play cowboy with guns on their hips and terrorizing people out on the street.
Okay. Yamini, I hope you have got your answer. Thank you so much for your question. And yes, if you have more questions, you can please give us a call on the number 425-436-6335. And don't forget to put the access code, which is 988888. Yes, I would again like to repeat the number 425-436-6335. And you can also, continue posting them in the comment section if you would like. And John, ZQ is here, and ZQ says, why is DHS even taking these steps? I think ZQ, like John said, to kick as many foreign nationals as possible and as early as they can, right, John?
Yeah. So it all makes sense when you look at Stephen Miller, who is Trump's brain when it comes to immigration policy. Stephen Miller wants to make America white again, Let's just be honest. That's what this is about. They think that having immigrants in the U.S. is diluting down our culture. But again, that aside, that's the motivation for this. They want to make life as miserable as possible to incentivize people to leave without having to kick them out officially. And so that's why all of their programs are targeted just toward making life miserable. What the short-sightedness of that is they don't realize the value added by immigrants, especially the highly skilled immigrants and their families. I mean, that's a huge flaw in their analysis and their reasoning, but that's where they're coming from. And until there's some changes at the ballot box and we get more reasonable people in positions of power, our only access to fix this is through the courts.
I mean, as sad as it sounds, I mean, that's the truth. And it's not, John, it's not only that you who's saying this. I mean, most of the shows that we have done with most of our attorneys, a lot of them are, echoing these same words, and they are saying the same thing. Okay, so guys, again, thank you for being here. And I would like to remind you all about this private webinar, which is coming up this Wednesday, November 5th at 4 p.m. Eastern Time, titled DHS Ends Automatic EAD Extensions. Are you on the list? John will be joining us to share his experience, and we'll dig into what this change means, plus discuss important details about a potential lawsuit you won't want to miss. It's a private event, so to join, email support@wasden.law and reserve your spot today. Again, that's DHS Ends Automatic EAD Extensions. Are you on the list? Wednesday, November 5th at 4 p.m. Eastern Time. Email support@wasden.law to get your invitations. Make sure to be there and register now. And again, I think we have got another viewer, and his name is Yeshwant. And Yeshwant says, to what extent can a signed petition backed by a substantial number of individuals influence USCIS policy decisions or trigger a formal review, especially regarding employment authorization rules? That's an interesting question.
So I don't think there's anything that's going to make USCIS change its mind or change its position on this. I think the only thing that's going to stop USCIS is the courts. They are, and it's not even USCIS really that's pushing this. It's the White House. And so you could have all of the logical arguments in the world from all the smartest people, and it's not going to matter. And that's a sad reality. Yeah. Logic and smarts really aren't the Trump administration's, strong suit. So, petition, the value in comments to this rule, because we still have a comment period. The value in comments to this rule is that it builds a record that we can highlight that the government ignored critical information when allowing this rule to stay final. And that's, the comments are playing to the court. They're really not trying to influence USCIS because they're not going to change their ways.
Okay, thank you so much, John, for answering the question. And thank you, Yashwant, for your question. And John, I would like to ask you about, what steps should employers take to prepare for this change?
So employers need to be ready to provide some type of support or documentation for the EAD application. Again, that necessity and convenience issue. So, employers writing letters explaining what this employee is doing, how they're critical to the U.S. company's operations or some aspect of the operations, and, how you're contributing. That type of information is great to have, and I think it's going to be essential to include that type of stuff in applications going forward.
Okay, and how will this affect I-9 compliance and re-verification for HR departments?
So those rules won't change dramatically. You can't work without an EAD, so you're going to have to re-verify when you get a new EAD, and if you are working without an EAD, then that's going to be a problem on your I-9. But it shouldn't really impact that a whole lot. The rules are in place, how to deal with compliance.
Okay, so if an employer continues to let someone work while their EAD is technically expired, could that company face penalties?
Yes, yes. The penalties range from being fined to potentially even criminal prosecution if you're a habitual violator and you just, keep hiring people and don't care about their immigration status or their employment authorization. But I don't know, I can't think of a time where there was a criminal prosecution on that, but it is on the books. It could happen.
Okay, okay. And how should HR departments prepare for this? I mean, should they be tracking EAD expirations more closely?
Yes, HR departments should really be liaising with the employee to get that documentation of what they're doing and how critical they are to the operation. So they should be the point of contact with the company to get the documentation that we're going to need for those applications when we file the EAD renewal.
So essentially, then both the sides, the employer and the employed, both are at risk if they don't plan ahead.
Exactly. Yeah. Because I mean, we had a lot of folks, last time around, there was physicians that were, in a 2-person practice in a rural area, and they were unable to work, and that had a huge impact on the rural population. And so, that information was great in court. We showed the actual real world impact that that's having on that community, but we were only able to really do that because the employer had provided information in the application showing how vital and essential this person was.
Okay. And John, what's your advice for employers who genuinely wants to support affected staff, but but don't want to break any rules too?
So there's no rules to break if you're just giving them a document explaining what they do, why they're critical, and the negative impact that your company will suffer if you lose them. And so be creative. Think about long-term effects of what's going to happen. Are you going to lose clients? Are you going to lose the ability to perform your job and make money and be profitable? Or do you have patients that are going to suffer? So employers just need to be creative in how they articulate why it's important for this person to keep their employment authorization.
Okay. Thank you so much, John, again for answering all these questions. Let me quickly remind our viewers about this private webinar, which is coming up this Wednesday, November 5th at 4 p.m. Eastern Time, titled DHS Ends Automatic EAD Extensions. Are you on the list? Guys, John will be joining us to share his experience, and we'll dig into what this change means, plus discuss important details about a potential lawsuit you won't want to miss. It's a private event, so to join, email support@wasden.law and reserve your spot today. Again, that's DHS Ends Automatic EAD Extensions. Are you on the list? Wednesday, November 5th at 4 p.m. Eastern Time. Email support@wasden.law to get your invitation. So register today. And John, I have, I think, a question that I missed out from a viewer called Cynthia. And Cynthia says, given my current visa and EAD category, I am affected by the October 30th rule change. And do I qualify for any exceptions under TPS or statutory provisions?
Potentially. I'd have to know a whole lot more about your case. If you want to make an appointment, we can talk about it and go over your particulars. But, it just depends. It's a typical lawyer answer. Depends on what the facts are surrounding your situation.
Okay. And Cynthia, if you would like to get in touch with John, you can, click on this link and you will be directed to John's website. There you will have all his details, his email, his contact number. So you can directly get in touch with him for your immigration case and for all your queries. But thank you so much for your question. John, if automatic extensions end, will this increase pressure on USCIS to process renewals faster?
So it'll create a backlog. And I don't think it's going to motivate them to move faster. I don't think it's going to motivate them to allocate adjudicators to process these cases. I think the whole point of it is creating a backlog. And that's, nothing's going to motivate USCIS to do something it doesn't want to do. And right now, it doesn't want to have people working in the US on an EAD.
Okay. So, before we wrap up, I think we have covered all our viewers' questions and also our questions too. So before we wrap up, John, what's your main advice to EAD holders watching right now, and what should they do to, to stay safe and to keep their work status protected?
Be proactive. Keep an eye on that clock. See when you're 6 months out from expiration. File, but when you file, make sure you have employer support explaining why you're important and why you matter and why you're essential. And you need to explain in your own letter in that application the impact it'll have on you professionally, the impact it will have on your family financially, and potential health issues. Now, if you're losing health insurance and for your children, that's a problem. And so all of those things need to be articulated when you apply, and simultaneous with that application, FOIA. And work with us on the FOIA. We'll put everything in there that needs to be in there, and we'll take care of that, and we will tee it up so that if they're dragging their heels on the adjudication, we can go into court, we can sue on the FOIA, we can sue on the delay, and motivate them to give you your employment authorization document so they don't have to give me attorney fees.
Okay. That's an invaluable advice. Thank you so much, John, for being here. It was, like always, an amazing discussion, an amazing webinar, a very insightful one. So thank you so much again for being here, and hoping to see you very soon. And I think, let me again remind everyone about this private webinar, which is coming up this Wednesday, November 5th at 4 p.m. Eastern Time, titled DHS ends automatic EAD extensions. Are you on the list? Guys, John will be joining us to share his experience, and we'll dig into what this change means, plus discuss important details about a potential lawsuit you won't want to miss. It's a private event, like I said, so to join, you have to email support@wasden.law and reserve your spot today. Again, that's DHS ends automatic EAD extensions. Are you on the list? Wednesday, November 5th at 4 p.m. Eastern Time. Email support@wasden.law to get your invitation. And register today, register now, so you don't miss this very important private webinar. John, thank you so much again for being here. It was, as always, lovely having you. Thank you for your insightful information and all those details and all those answers that you gave.
Hey, it was good to be with you. Thank you very much.
Thank you. And guys, I hope you enjoyed this conversation. I hope it was insightful to you as well. And if you did enjoy, to make sure to like this video and share this video with someone who you think can benefit from all this important information. And don't forget to subscribe to Immigration Talk Show and also Wasden Law channel. And I'm going to see you all very, very soon. But until I see you all again, make sure to subscribe to Immigration Talk Show and take care of yourself. Goodbye.